God save the state and this honorable court.
Good morning. First case is Sanders versus NCDOT, and we'll hear from the appellant.
May it please the court, I am Howard Rhodes of the Banks Law Firm for the Department of Transportation, and I will reserve 5 minutes for rebuttal. The plaintiff in this inverse condemnation case was paid just compensation for all damages to his property and is entitled to nothing more. The plaintiff knew about, but did not raise MAP Act damages caused in 1992 and 2006 on his property in 2 prior condemnations. He did not raise those damages. Instead, he chose to negotiate for and accept just compensation based on an unencumbered fee simple value of his entire tract at the appreciated fair market value in place in 2010. His current claim, filed nearly 8 years after he accepted just compensation, is barred by statute, barred by res judicata, and barred by our state's common law. The Court of Appeals in this case held correctly that plaintiff lacked standing to assert his claim on most, but not all, of the acreage associated with the MAP Act damages in 1992 and 2006. The Court of Appeals erred, however, by misinterpreting our state's inverse condemnation statute, Chapter 136-111, and our state's doctrine of res judicata to permit a claim under these circumstances. Put simply, when DOT files a condemnation taking interests on a tract of land, the landowner must raise any and all claims for damages to that tract existing at the time. Here, plaintiff knew about damages caused by the 1992 map when DOT filed a condemnation on the property in 2002. Plaintiff wrote DOT a letter in March 2004, several months before agreeing to a consent judgment in that 2002 condemnation, pointing out those MAP Act damages and asking DOT to accelerate its acquisition on his property for the Fayetteville Outer Loop, the very project for which DOT had recorded the 1992 corridor map. When DOT amended and re-recorded the corridor map in 2006, plaintiff subsequently wrote DOT another letter in December of 2008, again raising the problem of MAP Act damages on his property. However, when DOT filed a direct condemnation in 2010, plaintiff did not raise those damages in his answer by counterclaim or in the Chapter 136-108 hearing in the case. Instead, as I have noted, he negotiated for and accepted nearly $16 million in just compensation and entered a consent judgment which released any further claims for damages on his property. There are 2 fundamental bases for remanding this case with instructions to dismiss the complaint in its entirety. The first is a statutory basis. Our state's inverse condemnation statute, 136-111, has 2 elements of it that are at issue in this case. First is what could be described as a sort of precondition, that inverse condemnation is only available in cases when DOT has not filed a complaint and declaration of taking on the property. When DOT has filed a complaint and declaration on the property, DOT has initiated a condemnation procedure in which the statutes provide for a complete adjudication of any and all damages existing at the time on the property. That's a precondition. Here, DOT did file a complaint and declaration of taking on the property on 2 occasions, one in 2002 after the 1992 map was recorded, and a second time in 2010 after that map was adjusted and re-recorded in 2006. In neither of those cases did the plaintiff raise the MAP Act damages. So very simply, inverse condemnation is not available as a remedy in these circumstances. It's not available for a landowner to come back after accepting inverse condemnation, or accepting just compensation rather, and reopening litigation on the property. Now, the second element that has been at issue under 136-111 is the statute of limitations. The statute of limitations provides landowners 2 years after the completion of the project in order to file their inverse condemnation claim. However, that statute of limitations only applies in cases where the precondition hasn't been met. So in cases where DOT does file a complaint, a condemnation on the property, what that filing does is set the circumstances, the proceeding within which a landowner must assert those prior existing damages. Now, behind and beneath all of the legal doctrines at issue in this case is a fundamental reality. At the time that DOT files a condemnation on a property, the touchstone for the parties and the courts is what happens to the property's fair market value. In a circumstance where there are prior existing damages on the property, when DOT files a condemnation, those prior existing damages necessarily are having an effect on the fair market value of the property at the time that DOT files its complaint. And it's for that reason that the condemnation statutes, particularly 136-106, require landowners to assert affirmative defenses and all matters as are pertinent to the action. Now, the language
Can I ask you just why you think that that's sort of an axiom, that if there's been some sort of taking, even a temporary regulatory taking that occurred in the past on the property, that the fair market value currently must necessarily incorporate the damages that were suffered by that taking in the past? I mean, I can imagine some scenarios where it doesn't have a great impact on the long-term fair market value of the property, but has an immediate impact on the current property owner's expectation of the value of the property because you're generating some income from the property or something else. So explain to me what I'm missing here about the idea that the value you would calculate is always going to include whatever harms or accompanied some taking in the past.
Right. Under the specific facts of any given taking, I think, Your Honor, that's a well-taken point. It may not be the case. But in a case where the prior existing taking is of the nature of an easement, as is the issue within the MAP Act context and many other contexts, it's an ongoing encumbrance on the property. That's how that easement would be assessed. And that necessarily would have an effect on the fair market value at issue in the property.
Help me understand just, imagine you had a case where you recorded a MAP Act recordation that exactly what happens here. The state comes in later and says, oops, we never want to do that. Forget it. Unrecord it. And then also the state says, and by the way, we realized we do want to build a highway at some point, but we're going to build it 20 miles over. So nowhere near this property. And because there's going to be another interstate over there, every buyer is going to know there's not going to be another interstate on this property at any point in the near future. So why would the fact that it was recorded there 20 years ago impact the fair market value today of that property?
Well, I'll do my best to answer the counterfactual. But I think the important thing in the context of the MAP Act, given how many decisions by this court and the Court of Appeals have been issued, is that the MAP Act taking is assessed under the specific situations of what happens with the MAP Act easement. And what happens
But
there?
those cases, the thing, I understand that, but I want you to talk doctrinally, because the thing is, those cases never anticipated in their reasoning that the MAP Act would be repealed and that there could be scenarios where there would never be a taking later. So, so I don't think those say anything about what our takings law says about something like a MAP Act taking, which I struggle to figure out what words. I can't decide if this is a regulatory taking or what it is. It's certainly not a physical taking of the property. It's just a document that's been recorded, but it obviously, we've held it is a taking. So I'm just trying to figure out, how would you calculate those damages if that was the claim that was brought in some inverse condemnation proceeding?
Sure. Under the MAP Act, what it empowered DOT to do is take an easement restricting 3 rights for an unlimited period of time.
Right, but in my hypothetical, it's not unlimited anymore because they repealed it. So now it's just a temporary. All those things were just temporary in hindsight.
It's not temporary under the facts of how the MAP Act actually operated and was instituted. So the MAP Act restrictions were unlimited, not simply because nobody anticipated when they might be abandoned or something else, but they were restrictions envisioned both by the statute and, frankly, by the parties that would never end in any real sense, but would be absorbed into a taking of the entire fee for the purposes of the highway.
Right,
So I
but
think
then they repealed it and they never did the taking.
So then, right, and I see where Your Honor's question is going, but I think to arrive there, it's important to understand that that's what happened on the date of taking. Now, over 20 years later, an unforeseen and unknowable event happened where the General Assembly rescinded the statute. Now, how could that be irrelevant? Ultimately, the touchstone is fair market value. What this court found in both Kirby and in Chappell, and I think in reality, on the date of taking, when the corridor map was recorded, that's when it either destroyed or severely impaired the fair market value of the property. When the General Assembly over 20 years later rescinds the statute, it doesn't magically restore the fair market value of the property. Otherwise, just as again, a practical reality underlying the doctrine, what would have happened when the General Assembly rescinded the statute is that there would have then been a flurry of development, subdivision, right? Everything's okay. But the reality, of course, is that after 20 odd years, with no signal either in the statute or in any other way to landowners that this taking would or could be temporary in any real sense, the damage was completely done. And the General Assembly's decision to rescind is irrelevant both doctrinally and in terms of understanding the nature of the taking.
So this is where I'm just struggling, because then maybe I'm missing some foundational concept of valuation, but your argument doesn't make any sense to me. Why does a buyer on the market today care about those restrictions, which ended up just being a fiction, to whoever owned the property before? You're going to value it based on what you can do with the property when you take title to it, and those restrictions don't exist. So I'm just not seeing how you could say that they're built into the permanent fair market value. They've just gone away. So isn't the damages that must be paid for that temporary taking require some different calculation than just taking the property, either an easement or taking the whole thing in fee, that we think of as more traditional physical taking? And that seems to me, and I understand your point, which is, in this case, we may never need to get there, because procedurally, these claims may be barred. But as you know, there's another case coming up here in an hour, and we are going to have to grapple with it at some point. So I'm just trying to understand from you doctrinally where you're getting the support for the argument you're making.
And I just need to make sure I'm tracking your question. I understand. So is your question based on the condition of the property after the legislative rescission in 2016?
So I guess what I'm saying is I hear you saying that in every MAP Act case, you're calculating the damages by looking at the change in fair market value when you record it, this indefinite taking.
Yes.
And what I'm saying is that just can't be the calculation anymore. It seems to me now that we know what we didn't know in Kirby or Chappell. I mean, technically in Chappell it happened, but it wasn't before the court or argued by the parties. But now we know that the MAP Act is gone, and that seems to no longer be the correct method to calculate just compensation. And so I'm asking you, what are you just saying do it anyway because Kirby and Chappell said to do it, although they were never thinking about this? Or is there some other reason why we should still use that calculation when we know that the taking was temporary?
It is not irrelevant that this court has decided the issue twice, including in Chappell in 2020 after the legislative rescission. But directly to your point, it's not just because this court said so, but because what the department took by recording a map in 1992 or 2006 was the right to restrict those rights for an unlimited period of time. And that was the reality for over 20 years. And the length of time, the way in which the statute communicated to landowners that this was not temporary. So unlike the ordinance at issue in First English, unlike any temporary construction easement, what the statute itself does, as the court properly analyzed in Kirby, is that it communicates an unlimited taking. And so the damages to fair market value are imposed on the date of taking, irrespective of unknown future events in the future. Though that change doesn't retroactively transform the nature of the original taking over 20 years before, right? That retroactive, that's what it would need to mean in order to recharacterize the original taking as a temporary taking that implicates rental value valuation. The entire way in which the taking was imposed, what it communicated to landowners, the reality of how that easement was exercised over an extended period of time is unchanged by the General Assembly's rescission of the statute. And the fact of the matter in these cases is that in the case that's coming up next in Mata, 4 years later, the direct condemnation is filed and the fee is taken, right? Sanders is a different case. Sanders is a case where in 2010, the department filed a direct condemnation and took the entire fee that was covered by the 2006 map. The only acreage that the trial court left in play for a potential ongoing claim is 1992 corridor map acreage. So corridor map acreage that was not raised in both direct condemnations on the property, despite the fact that that acreage was covered by the 2002 condemnation in part.
So on Chappell, should we assume that the court was aware that the MAP Act had been rescinded when Chappell was decided? I mean, we say all the time, we assume the legislature knows the law. Should we assume this court knows the law?
I think the rescission of the statute is certainly a matter of judicial notice. It was not expressly inscribed in the opinion, but ultimately the Chappell decision doesn't hinge on the court judicially noticing the rescission of the corridor maps.
And if we agree with you that the plaintiff in this case was required to bring up the MAP Act restrictions when DOT certainly in 2010 when DOT filed a direct condemnation action. We wouldn't in this case get to the damages issues that you've just been discussing with Justice Dietz, correct?
That's true. That's true. In this case, the Sanders case, just to be clear, because the one issue that overlaps between the two cases is the issue of the measure of damages. So in Sanders, the Court of Appeals held that it was a temporary taking based on the rescission of the statute, and then applied a rental value measure of damages to the taking in Sanders. In Sanders, I don't believe the court ever needs to get there, because I believe that the claim is completely barred either by statute or res judicata, or properly, I think, both. The statute, res judicata, and frankly, to a lesser extent, the common law basis that the Court of Appeals actually adopted, all of those are complete and independent bases for barring the claim. And so the valuation issue, the court does not need to arrive at in Sanders. In Mata, that's the whole game. The Court of Appeals in Mata, as I'll discuss much more in the next hour, the Court of Appeals in Mata recognizes a temporary taking, but imposes a different understanding of that temporary taking and a different measure of damages. So, but those are the issues that overlap, and that will be an issue for the court. Ultimately, the statute is unavailable as a remedy under the circumstances of the Sanders case. The case is also clearly barred by how this court has understood the doctrine of res judicata. In the 2010 consent judgment, so just to be clear in terms of res judicata, what we have is a settlement that's inscribed in a consent judgment. And so the court's analysis is against the background of the way in which it is construed consent judgments as receiving preclusive effect under res judicata, but ultimately it's terms of contract analysis that apply. And what happens, particularly in the 2011 consent judgment, is that there are 4 categories of thing that just compensation is covering in that case, and it's all at the very end of the consent judgment at the record. The first is that just compensation covers all of the areas and interests taken by the department in the 2010 direct condemnation. Those are all listed and described in the consent judgment. So it is just compensation literally for what the department is taking in 2010. Second, fees and costs. Third, it covers all damages associated with an acquisition for the construction of the highway project. Now that language is significant because it differs from the language that you will see in the exact same position in the 2004 consent judgment. The 2004 consent judgment states that just compensation covers all damages associated with the construction of the project. In 2010, it's covering all damages associated with an acquisition for the construction of the project. That's precisely what the MAP Act was, of course, and in fact, there's nothing else that would qualify. Nothing else in the world that would qualify as an acquisition for the construction of the project that is in addition to the first category of damages, which is the actual acquisition in 2010. So that was a change in the language very early in the development of the MAP Act litigation. In fact, 2010 was the first year where MAP Act claims are being brought in the courts by landowners. And that was a provision where the language is intended to cover damages associated with any other acquisition beyond what is being identified in the consent judgment. And then lastly, of course, it's DOT's past use of the property. Now, it is a standard It's a bog standard way in which settlement agreements release claims using as broad language as possible in order to cover any possible damages that could recur. So the consent judgment does a very standard element of civil practice, which is impose a sort of ever-expanding release that covers anything that could possibly come back after this has been released. And that is res judicata. To the extent that it was a past use, which an easement under the MAP Act certainly was a use for the public benefit, it's released. And with that, I'm in my rebuttal time, so I will take my seat.
Thank you, counsel. Hear from the appellee.
Good morning. May it please the court, I'm Stephanie Autry, and I am here on behalf of William Sanders, along with George Autry and Jeremy Hopkins, my partners. We are here today because there's a very important issue with really grave potential consequences before you in the Sanders case. The department's position is that by taking 1 square foot of property, that it can thereby, without describing the interests that it is taking, without limiting the interests to those described in the consent judgment, that it may cut off an owner's right to further claims for compensation going into the future for the use of different areas and interests, and going into the past for claims that have already incurred. The implications for if the court went down that path would be tremendous. If the DOT can foreclose claims like that, no buyer would ever touch a piece of property that the DOT had ever taken anything from. Because if the DOT's interpretation is correct, then any and all damages caused by construction or caused by the acquisition for construction is unlimited, not limited to those particular interests and areas that the DOT has actually taken. It happens regularly. I've been doing nothing but eminent domain for 25 years. It happens on a very regular basis that there will be a 2010 taking for the Cliffdale or for the Fayetteville Outer Loop. That claim will be resolved, and then there's a plan change. And 3 or 4 years later, it turns out that DOT needs additional property for the same project. If this phrase, any and all damages for acquisition for the construction of this project, was intended not to be restricted to the interests and areas described in the consent judgment, then DOT could take those additional acres that it needs, those additional interests that it needs, with no compensation. And for that reason, no owner would ever settle his DOT case with language like that in the consent judgment unless the DOT agreed to pay him the entire before value of the property. Because the owner would know that the DOT could come back at any time in the future while that project was going on and say, no, we need more acreage now and we're not going to pay you for it. In fact,
I'd like to ask you about what I understand to be the department's statutory argument. I think what the department's saying is that if you have a tract of land that's subject to MAP Act restrictions, and then subsequently DOT files a complaint and declaration of taking for part of that tract, that the MAP Act restrictions are relevant to the calculation of damages under 136-112 because they affect the fair market value of the land immediately prior to the filing of that complaint and declaration of taking. And because those MAP Act restrictions are relevant to the calculation of damages, then under 136-106, they're pertinent to the action and have to be, the MAP Act restrictions have to be raised in the answer. I think that's one of their arguments. Am I correctly stating their argument, number one? And number two, how do you respond to that? Because the arguments that you've been making are very practical, but we have to grapple with the statutory language.
I think you are understanding the DOT's argument, and I think the DOT is wrong. There are a number of reasons why the pre-existing MAP Act claim would not be considered. It cannot be considered as impacting the value of the property at the time of the direct taking. An absolutely fundamental tenet of eminent domain law is the project influence rule. And that rule says that the DOT cannot use its actions in advance of taking property to build a road to depress the value of that property and then get the property for cheap. That would be fundamentally unfair, and that's what this court said in Kirby. This court said that the department could not use the MAP Act restrictions as a shield to prevent the DOT from having to buy land that had been developed and therefore was more valuable. That's just part of the equation. The DOT also cannot use the MAP Act restrictions as a sword, which is what it's trying to do here. It's trying to use the MAP Act restrictions to devalue the land that it actually needs to take to build the road. And the project influence rule says that you cannot do that. And the project influence rule is the subject of many United States Supreme Court cases. It's discussed in the Piedmont Triad versus Unger case, which I filed a memorandum of additional authority on last week. That Unger case is particularly interesting because that was a situation where, very similar to the MAP Act restrictions, there was a watershed ordinance that was put into effect. And under that watershed ordinance, very limited development was permitted on the property. The condemnor in that case, the Water Authority, wanted to introduce evidence that the property was restricted when it needed to actually take the property to build a reservoir. And the court said, no, you can't do that. You can't use restrictions that you put in place to devalue property when you need to take it in the future. Now, the DOT tries to get around that rule by saying, and there is an exception, by saying that the project influence rule doesn't apply if the prior restrictions that devalued the property were themselves a taking by eminent domain, as the MAP Act restrictions were. However, there is an exception to that rule, exception to the exception, which says if that prior exercise of eminent domain, which devalues the property, is within the scope of the same project that the DOT actually needs to acquire the property for to build the project, then you cannot consider the devaluation caused by those prior restrictions. And that's what this court said in Kirby. You can't use the MAP Act restrictions as a shield. You also can't use it as a sword.
Could your client have raised the MAP Act restrictions in the 2010 action?
Yes.
And isn't it the case that had your client done that, we wouldn't be here?
I don't believe that's the case for a number of reasons. First of all, Mr. Sanders still had over 28 acres that remained restricted after the 2010 taking. And although the DOT now takes the position that the MAP Act restrictions were permanent, we always, and other veteran eminent domain attorneys, the affidavit of Emmett Haywood is in the record, always took the position that it was temporary. And that's what the facts have borne out. And since it was temporary, we needed to know how long the duration would be. Not just for those 28 acres that continued to be encumbered after the 2010, but for the acres that were taken in 2010, because we needed to know when the construction was going to be done. Until the actual construction of the project was done, we couldn't figure out what the MAP Act damages were. When you look at MAP Act corridors, you don't see median breaks, you don't see driveway, you don't see driveway access points. So you don't know, you cannot tell what the difference is between the MAP Act damage and what you're going to be left with when the direct is completed. And as our pattern jury instructions say, you have to value the after in envisioning the project in its completed state. And furthermore, I would say that 136-111 specifically gives Mr. Sanders the right to wait not just until a direct is filed that touches the same property, but to wait until 24 months after the completion of the project, or 24 months after the taking or the completion of the project, whichever is later. And there has not ever been a single case that supports the DOT's position. There is not a single case which dismissed a MAP Act inverse or an inverse claim period on the grounds that a prior direct had already been filed. There has not been a single case which has considered an inverse claim as a compulsory counterclaim. To the contrary, there are numerous cases. There's the Bragg case, Cochran, Spratt, and one of the Town of Midland versus Wayne cases, which all considered situations where there was a taking, an inverse taking that occurred. Damages from that inverse were known to exist at the time that DOT filed its direct action. And despite the fact that those damages were known at the time of the direct action, the court said that an inverse could be filed subsequently. It did not have to be brought in the direct action. In the Bragg case, I think is probably the best one. In that case, there was the DOT took property from Mr. Bragg, and then across the street, not on property it had taken from Mr. Bragg, it did some construction, and that construction off of the Bragg property caused flooding on the Bragg property. And what the court said when Mr. Bragg tried to bring those flooding damages into court during the direct case was he should have been allowed to do that, but he didn't have to do that. He may, but they did not say he must. In fact, the court said that Mr. Bragg would have been able to move forward with a further taking in a subsequent condemnation.
So how do we square that with our case law that says that these condemnation claims are not personal, that if you sell the property to someone else, that the claim then passes to the grantee who now owns the property? Because I think the argument your friend is making is that's exactly what happened, and the state now owns the property. And so the state can't sue itself, obviously. It's not going to. So the claim's gone away. What's your response to that?
And I'm very sorry for interrupting you, but I'm so excited that you asked me that question. That is the only thing that the Court of Appeals got wrong in this case. The Court of Appeals relied on this one case, the Cavanis case, that's 110 years old, and that was decided under statutes that are completely different than those that exist now. If you ask the DOT whether they wanted to go back to the statutes that were in that Cavanis was decided under, they would say no way. The DOT is very, very glad that they have this quick take procedure. It's the only way that they can do business now. They need to be able to take property just by filing a complaint and declaration of taking. At that point, title immediately vests in the DOT. At the same moment that title vests in the DOT, the right to compensation vests in the owner because he's lost title to his land. The right to compensation is a substitute for the title that he has lost. That's what happens under the quick take statutes. Under Cavanis, which is the only case that the Court of Appeals relied on, that was not a quick take. This was back in 1916. It was when, if the condemnor in that case took property, even when it filed a declaration of taking, title didn't vest in the condemnor. Even when a judgment was confirmed about how much it owed, it still didn't have title to the property.
Couldn't we harmonize the cases by saying, we're not going to treat it like when you file the quick take action, that the property, for purposes of this sort of doctrine, we're not going to treat it as immediately upon filing the property transfer and you lost the right, but that during the proceeding, if you have those claims, you have to bring them. And so what we'd be saying is, after the direct condemnation proceeding concludes, the case is over and all appeals are exhausted, that after that point, you couldn't come in and bring an inverse condemnation claim that you had for that property because under these older cases, you're no longer the owner. The title has passed to the state and you can't bring those claims anymore. And that would seem to square the two doctrines together.
Well, except that Cavanis, if it hasn't, I think it has been repealed sub silentio. It's not good law anymore. If it was, North Carolina would be the only state in the country that followed that rule. Departments of Transportation around the country now use quick take provisions. And just like in a direct condemnation under the quick take statutes, title passes to DOT at the time of taking, which in a direct is when the complaint is filed. In an inverse case, title also passes to the DOT at the time of taking, and this court held in the Midget case that taking, when title passes in an inverse case, is when the injury to the property occurs. And that's what this court said in Kirby. The Kirby court said that it was the recording of the corridor maps that effectuated a taking, and the parties here stipulated to that. There is no basis for saying that the plaintiff in an inverse case should be treated differently than a property owner who is sued by the department. In either case, when the taking occurs, title passes and the right to compensation vests in the owner. And I can't recall whether there was another part of your. Okay. Thank you, Your Honor. I want to go back and address a few things that Mr. Rhodes covered. In particular, the Kirby decision and the Chappell decision, and what, if anything, they have to do with the issue of whether the MAP Act takings were permanent or temporary. One of the best cases that we rely on here is the Arkansas Game and Fish case, which is a United States Supreme Court case. And in that case, the Supreme Court had said in a prior decision, the Sanguinetti decision, that our jurisprudence requires permanence when it comes to flooding damages in order to support an inverse claim. And the condemnor, the department in the Arkansas Game and Fish case, which was also a flooding case, inverse case, said, wait a minute, we made a passing reference to permanence in the Sanguinetti case. We don't read the word permanence in Sanguinetti, and I like this quote, as having done so much work. The court said when a case like the Sanguinetti case mentions a term or a doctrine, but the case, that case is not actually deciding that issue, it's akin to dicta. Those sort of general expressions, the court says, are to be given some consideration, but they are not binding when a case comes along where the court is actually deciding the issue. The Kirby case was not actually deciding the issue of the duration of the MAP Act takings. It was deciding whether there was a taking at all. And so the court in Kirby said indefinite, not infinite, not permanent, but it said indefinite when it was deciding whether it was a taking at all. And the fact that it was indefinite went into the court's thinking about the fact that it was a taking, but it was not a decision that the duration of the MAP Act was indefinite. And the decision in Chappell, you know, I think the court, the trial court proceedings in the Chappell case were frankly a mess. And I think this court held its nose, didn't want to upset the jury verdict if that could be, harmonized. And what the court said in the Chappell case is the characterization of the MAP Act taking as never ending was harmless error on the facts of this case. Now, we submitted an amicus brief in the Chappell case urging this court to limit the Chappell holding to those facts, because we believed then and believe now, our position has not changed, that the MAP Act taking was temporary. And this court did that in Chappell. It did not adopt the Owners' Council of America amicus position because that evidence had not been before the jury in Chappell. But it did limit its holding in Chappell to the evidence that was in that case and merely held that it was harmless error to characterize the taking as indefinite. I want to move on and talk a little bit about res judicata and about the consent judgments. I've said that if the department's interpretation of the consent judgments was correct, then you would never be able to sell property that had been touched by the MAP Act. There would be no certainty in the chain of title. That's not just because of the phrase acquisition for construction, but also because of the phrase past and future use. DOT wants to dwell on past use, but what the consent judgments say is past and future use. If past and future use is not modified by the word thereof, which describes the interests and estates actually described in detail in the consent judgments, then any taking, no matter how small, from Mr. Sanders' 650-acre tract would allow the DOT to come forward at any time in the future and use any of the rest of the property. You would never be able to sell a piece of property. With regard to those phrases in the consent judgment also, Mr. Sanders the department was required to file the 2010 direct action because it needed the land to build the road. If it's, as it says, the MAP Act takings were actually an acquisition for construction of the road, then the department wouldn't have needed to file the 2010 direct action. It would have already had the rights that it needed to build the road. And if past use And future use gave the DOT the right to use any other part of Mr. Sanders' property in the future, not just those described areas and interests. Then the department made a $15 million mistake in paying Mr. Sanders in 2010 because that 2002 action would have given DOT the right to future use of the entire Sanders tract.
But doesn't that, I don't understand DOT to be making the arguments that you do, that this consent judgment somehow will entitle them to every piece of land that Mr. Sanders owns, or he'll have no remedy if there's a construction impact on land that isn't the subject of the 2002 and 2010 Direct Condemnation Act. But isn't your point exactly that DOT is not interpreting, like they still owed him something in 2010, which means the worst case scenario that you contemplate is not what is in effect being argued or sought by DOT?
No, what I'm saying is that the interpretation that DOT now says is correct is belied by its actions, because it did file the 2010 direct action, even though if its current interpretation was correct, it wouldn't have needed to do that. Another very important thing that I would like to point out is the fact that these negative easements, which is what the MAP Act restrictions were, are their interests in land. They are required, just like any other easement, to be described with particularity so that they satisfy the statute of frauds. No title searcher, nobody looking at the chain of title would ever know that the MAP Act restrictions had been conveyed or barred by the 2010 or the 2004 consent judgment. Another point that I think is extremely important and could serve to limit this court's the scope of this court's ruling is that the consent judgment that DOT drafted, every phrase, any and all damages caused by the acquisition for construction, past and future use, all of those phrases are modified by acquisition for construction of U-2519 CB, which was one section of the Fayetteville Outer Loop. Mr. Sanders' property was acquired for both CA and CB. Most of his property was acquired for CA, not CB. So all of this argument about the consent judgment is irrelevant to all of the acquisition from Mr. Sanders for Section CA. Now, we're not saying that Mr. Sanders still hasn't been paid for CA, but we're saying the department wants to stretch and stretch and stretch the terms of the consent judgment that it drafted, but the way it drafted it, it only contemplates barring damages for one section of the project. The other points that I would make regarding the consent judgments are that under the Spratt case and the Cochran case, this court looked at, and the Court of Appeals in this case, said that it is the department's pleadings which parameterize and define the scope of claims that DOT, that Mr. Sanders has to respond to. Those were the only claims that Mr. Sanders had to raise, and 136-111 and its statement that Mr. Sanders had 24 months or until the completion of the project confirms that. The MAP Act restrictions were not pertinent to the scope of the direct action as defined by DOT. It defined the scope of the action by mentioning the date, the interests, and the areas. And under Spratt and Cochran, that's what Mr. Sanders had to respond to. he had to bring up any and all damages to the entire tract flowing from that acquisition. But those are damages to remainder, and they are within the scope of 136-112. He did not have to bring up anything that was outside of the scope of what DOT actually described in its complaint. Mr. Sanders had separate claims. He had a MAP Act taking before the direct taking, and he had a MAP Act taking that continued afterwards. He is entitled to be paid for both of them. What the DOT is proposing to do is to treat Mr. Sanders like a neighbor who had a direct taking but never had a MAP Act taking. And Mr. Sanders' property was restricted for 24 years, so that would clearly not be fair. The other thing I wanted to mention is that the DOT explicitly waived MAP Act claims in other consent judgments at about the same time as this, somewhat later, but Mr. Rhodes points out that Mr. Sanders and DOT knew about the MAP Act claims. DOT drafted the consent judgment and certainly could have.
Thank you, counsel. I believe your time's expiring.
May it please the court. If the MAP Act were a matter of project influence, the landowners would never have had a claim. So project influence rule is not applicable to actual takings. That's black letter law articulated in many decisions at the federal level and frankly at the state level. The project influence rule is intended to bar from consideration in a condemnation proceeding any influences on the fair market value of a property that are created by the government other than actual takings. And what we have in the case of the MAP Act is, as this court found in two opinions, an actual taking because the statute imposed actual restrictions on the property. So to the extent that there is any argument about the MAP Act as a matter of project influence, it just goes by the wayside. The rule doesn't apply. Many of counsel's other arguments are premised on some confusion about the order of events in this or any other condemnation proceeding. So what we have here is a taking under the MAP Act that occurs prior to direct condemnations. This court has been very clear in two 1983 cases, Bragg and Leah Company. Bragg was mentioned and discussed by counsel that if there is an inverse condemnation or if there is a direct condemnation proceeding filed by the government and there is a subsequent further taking. So something else, for instance, happens during the actual construction after the condemnation has been filed. Landowners have a choice to either bring that inverse claim for those subsequent further damages in the condemnation proceeding itself, or they are free to bring that inverse claim later. But that is all about subsequent further takings. Right? And it's expressly laid out in every opinion where there is a subsequent further taking by the state, not something that existed prior to the filing of the condemnation itself. The landowner is entitled to pursue inverse condemnation. DOT's argument here.
You're also conceding that a landowner could bring that inverse condemnation claim if it's one that arose before, during the direct condemnation. You're not suggesting the state can rush in, file direct condemnation, and extinguish those claims.
Not at all. I would be arguing against a mountain of case law to the contrary. It's very clear from this court and from our Court of Appeals that a landowner can bring by answer, counterclaim, or even as late as a 136-108 hearing, any claim for inverse damages caused on the property. And it is, it's very protective of landowners and their right to assert a claim for just compensation. But it must be brought. The rule simply is not that because there is a statute of limitations within 136-111 that applies 2 years after the conclusion of a project, that come what may, landowners are entitled to sit on their rights until 2 years after the completion of a project. When DOT files a direct condemnation, it is doing precisely what it is supposed to do. And if it is not covering all relevant damages, that is the opportunity for landowners to raise them, and our courts have been very protective of that. Lastly, counsel raises a number of issues concerning the language in the consent judgments. Under the doctrine of res judicata, this court has recognized that the doctrine is intended to force parties to bring the entire suit within the lawsuit that is going. It's intended to force them upon penalty of being barred from raising partial claims that with a modicum of due diligence could have been brought at the time. So to the extent that there are any limitations in the very broad and expansive release.
Thank you, counsel. I believe your time's expired.
Thank you.
Thank you. Mr. Clark.
All rise.